5th District of the State of Florida is now in session. The Honorable Thomas B. Sawaya, Judge presiding. All persons having business before the court, draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning, and welcome to this session of oral argument of the 5th District Court of Appeals. It's certainly our pleasure to preside over the cases on the docket this morning. Let me introduce the panel to you. I'm Judge Sawaya. Seated to my right is Judge Berger, and to my left is Judge Edwards. We have 3 cases on the docket this morning. We're going to take them in the order presented. I'll re-announce that the case of Wilson versus J.P. Morgan, oral argument has been dispensed with. So if you're here for that case, you may leave. Each of the cases is a civil case. Each side will be allotted 20 minutes. We have a clock on the podium that will assist you in keeping time. If you have a problem with that, let me know. If the appellant wishes to reserve any time for rebuttal, let me know, and I will certainly assist you with that. If you have any electronic devices, cell phones, please turn them off so that we're not interrupted during the course of the oral argument. So we'll begin with the case of Boys Club versus J.A. Okay, appellant may proceed. Let me get the clock set. All right. Sir.
If I could, Your Honor, I'd like to reserve 5 minutes.
Okay.
May it please the court?
Okay.
I'm Kenneth Glaspie on behalf of the Appellant Boys and Girls Club of Marion County. I'm here before this court today as we believe the trial court erred in denying defendant's motion for... Let
me get right to the second issue, actually, that I've got listed on my notes, and it has to do with the remitter and the granting of a new trial. And to me, it seems like it's a preservation issue. I understand from reading the record that you filed a motion for remitter, or alternatively for remitter. The trial court granted it. The other side disagreed with the reduction of damages, and so the trial court ordered a new trial, which is standard procedure, right?
Correct, Your Honor.
Right. And now you are arguing that the jury basically compromised its verdict, and that was the result of the verdict that the jury returned, and that the retrial on damages alone would be prejudicial.
Yes,
and so my question to you is, where in the trial court did you make that argument?
Your Honor, we initially believe we made that argument when we made our motions for a directed verdict, when we had the rehearing set for the remitter.
No, but where specifically in the record did you argue that the jury returned a compromised verdict?
After looking through, Your Honor, that was not raised at that point in time. So I concede that
that's your argument on appeal, right?
That's one of the issues on appeal.
If you didn't raise it in the trial court, it's not preserved for you to raise it in this appellate process, is it?
I understand, Your Honor.
Do you agree that that you abandoned it and that you waived it essentially?
Yes, Your Honor.
Okay, so we'll move on to the first issue?
Yes, sure.
Go ahead.
Okay. Again, we believe that the court erred in not granting the motion for directed verdict or a motion for judgment notwithstanding the verdict. In this case, there was no evidence of the breach of negligence of the defendant in this case. The investigation that was involved by the Ocala Police Department, which encompassed the majority of the witnesses called in the plaintiff's case in chief in this, they were focused on the defendant in the criminal action, the other minor member of the club, and not on the club itself. There was no testimony as to the number of employees of the Boys and Girls Club that were present at the point in time put on by the plaintiff. There was no evidence put on as to how it should have been supervised. The only evidence put forth was that this alleged attack took place, and because it took place, it's negligence on the defendant's part. It was more of a res ipsa case. In the preliminary portion of the trial, when we were going over our initial jury instructions, the plaintiff attempted to get in a res ipsa jury instruction, which the court denied, but in the end, they essentially presented a case based on the doctrine of res ipsa. They said that because this happened, because they were there, it must have been the defendant's fault. There was multiple cases on point in dealing with school boards and sexual assault cases involving student-on-student attacks. And in all those cases that we've cited in our brief, there was something different involved where they overturned a directed verdict that was entered or not entered, and the common factor in all those threads was that the attacker who either assaulted or in some cases raped another student, that the school had specific knowledge of the propensity of these attackers. In one such case in specific, if we go to the Collins versus School Board of Broward County, which is 471 Southern 2nd, 560. This was an alleged sexual assault that took place in a shop class. And in that case, the court found that through the testimony, it wasn't even clear whether a teacher was present in the room, that on the day of the attack, it was a substitute teacher who was there, not the regular shop teacher, that this was a larger class with dangerous machinery, that there was a heightened duty of supervision. There was also testimony that the alleged attacker in that case had sexually aggressive behavior demonstrated before and had been suspended by the school on a number of occasions before it. Therefore, the school was on notice of this person's dangerous propensities and did not warn the substitute teacher and did not provide the additional supervision as was required.
Let me ask you this, what duty did the Boys and Girls Club owe to the Angus family?
I believe that the duty owed was more of the duty owed to a business invitee, because in the school board cases where the defendant or the plaintiff was arguing, in the school board cases they apply what's known as the in parentis loco standard. The reason for the application of that particular standard, as the courts have stated, is that school was compulsory attendance. Students were required to attend. Because they were required to attend, because they were required to be there, that the school stood in place of the parents.
So you think these children are business invitees?
I think they're closer to business invitee than they are to the school district. I don't think that the in parentis loco standard applies here.
Why wouldn't just the reasonably prudent person standard apply in this case?
Even under a reasonably prudent person standard, we believe that
Mr. McRae said that it was their responsibility to supervise the children and take care of them?
Yes, Your Honor, and I agree with that, but there's a difference between the two standards of the heightened duty that a school board has, because they are required to be at the school. Where at the club, they're not required to be at the club.
Well, to determine the standard of care is essentially a legal question, but whether the standard of care was breached is essentially a question of fact for the jury, right?
Yes, Your Honor.
Right. So you say that it's the duty of a business invitee, and that was their duty. And if I say that it was a reasonably prudent person standard of care, what would be the difference between the two, and how would that affect the outcome of your argument?
Well, I think, Your Honor, between the two, it exists the same duty that there's a duty of supervision in the general aspect, but there is not a duty for individual supervision.
Well, if you're a business invitee, you have to warn of dangers that you actually know about, right?
Yes, Your Honor.
But here, you're saying that they didn't actually know that the student had criminal propensities of a sexual nature, right?
Correct, Your Honor.
But, so if we say that the standard is a standard of a reasonably prudent person, how does your argument differ in that respect?
Well, even if we go to the reasonably prudent person standard, then I would still stick to the similar argument in that what duty do we have to supervise the interior of a bathroom where minor members are using it? There is no duty founded to supervise a bathroom.
Okay, now we're talking about breach of the duty, which would be for the jury to determine, or are we talking about a legal issue for the court to determine?
I'm talking about, I mean, in a sense, I believe it's a legal issue, Your Honor, is whether or not there is a duty in law to actively supervise the...
You're saying there's no duty at all other than the breach of a duty owed to a business invitee?
No, Your Honor, I don't believe that there's a duty to provide supervision of the restroom itself inside the restroom.
Okay.
But the Boys and Girls Club did have a policy in place regarding monitoring of the hallways and restrooms.
Correct, Your Honor.
They had a policy in place for monitoring these areas, and they neglected to do what their own policy required them to do if they breached a duty that they undertook.
But there's no evidence that they failed to undertake that duty to they regularly check the restrooms. In fact, part of the testimony from the plaintiff in the case, he stated that while he was in the restroom being attacked, that somebody had walked in and walked out. They alleged that it may have been one of the supervisors for the Boys and Girls Club, but that he couldn't signal because his mouth was covered. So even at that duty, then what does it take it to the next level? That the client must look over each stall to verify who's in the stall or what's going on in the stall. I think that it's bordering the line between what is supervision versus what is intrusion.
What about the representations that were made by Mr. McCrary and the young lady, is all she's described, there's no name, that they would separate the younger children from the older children? Mr. McCrary said they would do everything in their power to make sure the children were safe. Things of that nature. This was not bring your kids, drop them off, and good luck to you. This was affirmative statements that they would indeed take care of the kids.
Well, the children were separated by age, but it doesn't say what age that separation takes place at. There was a teen center where the students in middle school and above were at, which was in a separate building, and there was this main building. Now, in the main building, the older students did come in to use it because it was the only facility with the gym, it was the only facility with the canteen, but that was in the central area. Even the plaintiff's mother, when she testified, said that the boys were at separate, or the boys were kept separate in the gym, that there was the older boys at one end of the gym and younger boys at the other end of the gym. We're talking about the difference between a 12-year-old and an 8-year-old, both of which age groups would regularly attend middle school or elementary school at the same age. If you look at the age groups where schools are broken at, you have between 5 and 11 and 12 are all kept at the same elementary school. And then you go up to the next grouping, which would be the junior highs, and they're kept in about 4-year to 5-year age differences from the youngest to the oldest. We're not talking about a case here where an 8-year-old was assaulted by a 17-year-old. We're talking about a case where kids were a couple grades apart, for the most part.
You pointed out in your brief that there was not any expert witness testimony about what the duty of care was. Do you have any cases that say there must be expert witness testimony in a case like this?
No, I was looking for a case on point for that, but no, there was nothing on there, but there was nothing articulated as to what standard or what breach there was. There was no expert testimony stating...
The standard of care is a legal issue for the court to decide. Why does the court need expert testimony to help it with that?
Well,
you don't have expert testimony to help it with legal issues, do you?
No, Your Honor.
Decide, right?
And I guess I misstated. It was more towards the causation issue of it, as far as stating what...
Yeah, causation is a question of fact for the jury. We're talking about, and Judge Edwards was asking you about the standard of care, and you seem to indicate that there was no expert witness testimony as to what the standard of care was. And my question to you is, why is that even necessary if it's an issue of fact for the trial court to determine? And experts don't provide opinions on legal issues, do they, generally?
No, but again, I think that
So what does the fact that there was no expert witness testimony as to the standard of care have to do with anything?
Again, Your Honor, it may have been a misplaced argument as far as what it was supposed to be there. If you look at what the adequacy of supervision should have been, what they're alleging should have been, and they didn't put it...
We're talking about breach of the standard, right, which is the question for the jury to decide.
Yes, Your Honor.
Right. And maybe expert testimony would be helpful there, and maybe it would be relevant, but that's basically a jury question, and the jury decided that question against your client, right?
Yes, Your Honor.
And so you're saying that we should set that finding aside based on what? Because there wasn't sufficient expert testimony as to the causation issue now?
Well, there wasn't testimony as to what the improper supervision was, other than there was a 5 to 10 minute window where the child was not specifically accounted for. Essentially, again, it seems to me that's a res ipsa argument, that since we don't know what happened during this...
Didn't instruct on res ipsa, did it?
He did not, Your Honor.
So you're just saying that that's what your view of this case is, it's just res ipsa and that's it?
Correct, Your Honor. I think that's the way they went with it. Again, if you look at the sexual assault cases, again, this is another one, Miami-Dade County School Board versus AN. This was a sexual assault case that occurred between 2 kindergartners in the restroom. In that case, the plaintiff presented evidence that the school failed to give sufficient warning to a substitute teacher, again, that the attacker was known to have aggressive sexual tendencies. In King versus Dade County Public Education, this was a student who was assaulted, just beat up.
Your argument to the trial court that there was insufficient evidence as to the causation issue, or there was insufficient evidence as to what the standard of care was?
It was on both issues, Your Honor. Yes, Your Honor. In the King versus Dade County Board of Public Education, it was another student who was assaulted by students in the restroom at North Miami High. And what they found in that case is there was approximately 20 students that were moved from another school who had various problems with assault, suspensions, and things like that were involved with this. And again, they did not provide ample warning back to the teachers to provide the additional security, the additional care. In the cases that they go into, they mention the same thing. And the plaintiff's entire argument that was presented to the jury was there was a lack of a sign-in and sign-out procedure, was proof of negligence of the defendant. The sign-in and sign-out procedure in no way caused or contributed to this incident. One of the factors they allege is that the incident happened. One of the ones they asserted was that there was no specific person assigned to supervise the restrooms. Again, we believe that's a duty not found in law, to have a supervision of the restrooms, as that, again, you have to weigh the balance between what is appropriate supervision and what's invasion of privacy. In Collins...
4 minutes and 19 seconds, if you do want to...
I'll reserve, Your Honor.
Good morning. May it please the court. Dave Guiley on behalf of the Appellee in this case. Your Honor, our position is, as the court knows, and from our brief, Judge Rogers made the right decisions when he made the rulings that are now before this court. And we're asking the court to remand back. Essentially, I'm going to rest on our brief. I do have a few points to add. It seems to me like the essential argument here is the sufficiency of the evidence on any alleged breach. And the duty begins, as we know, Rupp has laid it out, and Collins' case has laid it out as far as the duty, and Judge Rogers laid it out for everyone in this case at the beginning and at the end of the trial when he instructed the jury. And it was to supervise and to protect.
Their position is that it should be a new trial from beginning to end. Are you satisfied with a new trial just on damages?
Yes, sir. We objected to the remitter, but then the court went ahead and followed the provisions of the statute.
But absent, if we say your objection to the remitter is not one that would be well taken, then you'd be satisfied with a new trial just on damages?
Yes, sir.
What is the duty that was breached? I mean, specifically, what's the duty that the Boys and Girls Club had?
Well, the duty that was breached was duty to supervise and to protect, and that was breached, and it's a much broader picture than what the appellant may wish to characterize here. It's not just a bathroom incident. And in this particular case, there was direct evidence in front of this jury, beginning with that first prior incident when the husband showed up and walked out with a child, and then the mother became incensed because no one there had ever met the husband before. And that's what initiated the check-in and check-out procedures that were later followed. And this is in addition to all of the repeated assurances of my child will be safe, my child will be kept safe. And
you argue that there must be a bathroom monitor or checks of each stall?
No, I think, I'm sorry for interrupting.
Go ahead.
I apologize. I think what this case shows is, number one, there was like a double standard for the supervision, plenty of supervision in the rooms, but in the hallways and in the restrooms, it was happen chance pretty much. Nobody was assigned, there were no regular rotations, there was no bathroom pass policy, anything like that. And when kids would leave a room, they were no longer supervised. Whether they would show up into the next room was unknown, and I think probably the biggest event in this case was the day of the event itself, when you had this period of 10 to 15 minutes, and the mother was unable to find anyone in that building who knew the whereabouts of her son. And that went on for 10 to 15 minutes. And there's different testimony as to the amount of time, but it's not her testimony is not disputed on that. And that's the accountability for the child. If there had been some regular program, or if the children knew, if the 12-year-old knew, for the purposes of deterrence perhaps, that somebody would be checking this restroom, somebody would be coming around, or that's accountability. There was no program for accountability for where the child is at a given period of time, other than when the child shows up in a room. We're not disputing that. They had supervision in the rooms. The next is the separation. Well, Mrs. Angus was told many times by Mr. McCrae that the children would be separated, and they were in the rooms. And the gym was the best example. The smaller children at one end, the larger children at the other. But those same children, when they left a room of supervision, were allowed to enter a hallway, hang out, do whatever. Maybe they could even go outside. And there's no testimony that came out where there was any accountability for that. And of course, the same applies for the restrooms. No accountability. There was no expectation by any student using the restroom that there would be an older person or an adult coming in to check on them and check the restrooms. Something happened in that restroom that day, whether you believe the entire case or not, based upon the testimony. But something very inappropriate happened in that restroom, and it should never have happened. And it was probably going on while the mother was frantically going up and down the hallway, fighting people, having several conversations, at least 2 conversations with Mr. McCrae, at least 2 conversations with the supervisors in the game room, before it was finally decided to look. And as far as breach, I just remind this court of the law of foreseeability, and Good versus Disney is a huge case in this state on foreseeability and foreseeable harm. And you don't have to see the exact harm. And Ruck versus Bryant spoke to that. And these all came out about the same time frame, about 30 years ago now. That's the law in Florida. And a lot of these cases, they happen, sure, there's other known circumstances about tendency of certain children, or maybe some are emotionally handicapped or morally handicapped. But in any event, in this case, the first prior incident we've already talked about, accountability for the child, who was with that child when the unknown father left. The second incident was at that elementary school while the children were waiting on the bus. And until the child battered this child. And
Neither one of those incidents really affect this. You're saying somebody should have monitored this child to make sure he was alone in the restroom.
I am saying that, but even that second prior incident that I just mentioned, that has to go to the separation, because the mother asked Mr. McCrae, please make sure that my son is separated from that other boy that caused this incident. And these are 2 elementary kids.
But the other boy was not the same boy who committed the assault, as far as we know.
As far as we know, and more likely at the elementary school, it was probably not the 12-year-old.
As a practical matter, how would the supervision be carried out? Would it have to be with your bathroom pass as one option, that only one child at a time could be in the restroom?
Well, certainly that is one option. Another option, I suppose, would be separation to begin with, and let the older children go maybe at different times. I mean,
How do you know where to cut, how does the Boys and Girls Club know where to cut off the age? This was an 8 and a 12-year-old?
that it was, and what's significant about this case is there was no policy, there was no attempt. That's what this case is about, a lot of lack of concerns for safety when there should have been. There should have been policies and procedures of some sort, there were none. If there had been at least some policies or procedures in place, maybe the outcome of this case would have been different in front of this jury. But it wasn't. And there was just overwhelming evidence from the beginning of the story where this young child was under the supervision and protection of the Boys and Girls Club, beginning early in the summer until late in September when this event occurred. And there were...
The impact of the assurances made by Mr. McCrary and the young lady, what role does that play in the duty? In other words, Mr. McCrary saying we keep your child safe, we do everything to keep him safe, and the young lady saying we keep him separated. Does that add to the duty, you think?
I don't think it adds to the duty. I think it reinforces the existing duty, and I think it acknowledges. It's knowledge is what it is. Knowledge of the duty, knowledge of the responsibility. That's what it amounts to. With foreseeability, there's a lot of things that can occur. Of course, we address this in our brief, and the same thing that the courts have already addressed about it can be crime, it can be just bullying, or it can be fighting. I mean, things happen, as the rep court said, when there's an absence of supervision. When there's an absence of supervision somewhere, there's a greater likelihood that there's going to be misbehavior on the kids. Just like the one case, it was a sexual assault, but it wasn't a sexual assault, it was a cafeteria case, and I believe it was when the girl was going up the stairway after leaving the cafeteria, and the boy was trying to trip her, and there was his teacher nearby, but what happened was, he turned around and then hit the girl. And so we ended up with an assault. And of course, that case was determined to be for the jury. But things like this occur with kids. We've all gone through that, and we've all seen it with children and grandchildren. And things happen in places where kids are congregated together, and even when they're under the direct supervision and control of somebody. And we never argued in loco parentis, we never argued res ipsa. It's the broader responsibility, the duty was to supervise and protect the children. And that was acknowledged by direct testimony. It's also acknowledged in the cases. And I still believe, as I said in the brief, Judge Cowart probably said it best when he summarized that Orlando Sports Stadium case about the duty of any responsible adult. And that can apply in the school setting, it can apply in the business setting, it can apply in somebody's home when the babysitter is there. Because it's almost a universal type of duty, of responsibility when you have older persons charged with responsibility. When you hire the babysitter, they have that responsibility to supervise and to protect. And I believe there's plenty of evidence that went in before this jury that was direct evidence, and besides all the direct evidence on pages 30 and 31, I try to suggest a lot of other reasonable inferences that a reasonable person could draw to conclude that there was a breach and there was causation. And that's essentially our argument. Any other questions for me?
No, thanks.
With that, I'll sit down.
Thank you.
Thank you so much.
If I may, just in response briefly, it goes down to the supervision that was required in the restrooms. He talked about a bathroom pass or hallway pass. I mean, this is a club that has over 200 members with a single restroom facility. What they're talking about for separating that and breaking down a restroom. It's no different than a public restroom at a mall. You don't separate who can go into a restroom. Anybody goes in there, goes in there.
Yeah,
In
but
a school,
the mall is a bit different. I mean, the boys and girls, their job is after-school care of children. It's a bit different than a public place at a mall.
and I agree with that, Your Honor, and I would go to the same thing as we could jump to an elementary school. In elementary schools, there's usually one or two restrooms, and even if a teacher hands out a pass for Johnny to go use the restroom, that teacher doesn't know what other classrooms have also elected to send their Johnnies to the restroom.
Yeah, but if the kid doesn't come back within a reasonable amount of time, I mean, you're probably in a school situation going to have the teacher go looking for the child or send someone else out to look for the child. That isn't really what happened in this particular case. And the child was gone and nobody knew where the kid was.
Again, Your Honor, we're talking about a period of, depending upon who you look at, 5 to 10 minutes of where they're wondering. I mean, he claims this was a giant search. The evidence shows that this building is not that large. From the time she walked in, the plaintiff's mother, she looked to the left, she sees the computer, or the games room as it's called, her child's not in there. 50 feet down the hallway is the entrance to the gym. So this isn't a large, sparse building where there was this search. Is he in the games room? No. Mr. McCrae, is he in the gym? No, he's supposed to be in the games room. Well, he's not. Mr. McCrae turns around, checks the gym, he's not in there, he goes into the restroom. This was not a massive campus that they're trying to search for. This wasn't this undetermined search time that went on. It was, is he in there? No. Is he not in the gym? He's in the restroom. It's the same thing with a teacher. Would a teacher think that she has to go search for a student who's not returned from the bathroom within 5 minutes?
If there was just one bathroom and the campus was as small as you say it is, and that would make it a little bit easier to have someone to supervise the smaller area and the one bathroom, right?
Yes, Your Honor, and the supervision that he's referring to within the rooms, the hallways, there was no specific person assigned to supervise the hallway because the hallway was visible from all the rooms. There was no specific person assigned to supervise the restroom because the restroom was connected to the hallway, which was plainly visible from all these rooms.
There was supervision. You're just saying that, you didn't have to have someone there in the restroom while the student was using it, right?
Correct.
Supervision, right?
Correct. I mean, essentially,
So there was a duty to supervise, right?
there was a duty to supervise, yes, but how far did that duty extend? Does that duty extend into examining the restroom, who's in there, how long they're in there, set timers for them, go in and jump over walls and look who's in there? There has to be a reason to elevate that duty to what do I check at the next level, which is what Mac McCrae did once he was alerted. He went to the next level and physically jumped over and looked, which ordinarily would be, I think, a major invasion of privacy.
Okay.
Sorry.
Okay, thank you.
Thank you.
Okay, thank you both.